Defender's Office either yesterday or today?
Yes.
I have a complaint that alleges that on or about November 3rd, 2025, in Antioch Township and or Boone Township of Wexford County, that is alleged in count number 1 that you committed the offense of homicide, murder in the first degree, premeditated. That is a felony punishable by up to life in prison without parole and DNA to be taken upon arrest. In count number 2, it's alleged that you committed the offense of homicide, felony murder. That is a felony punishable by up to life without parole and DNA to be taken upon arrest. Both of those charges involve Rebecca Park. In count number 3, it is alleged that you committed the offense of torture. That is a felony punishable by up to life or any term of years. A consecutive sentence may be imposed under MCL 750.506 if the assault happened in a place of confinement. In count number 4, it is alleged that you committed the offense of conspiracy to commit torture. That is a felony punishable by up to life and or any term of years and a $10,000 fine, and consecutive sentence may be imposed if it happened in a place of confinement. In count number 5, it's alleged that you committed the offense of assault, pregnant individual, intentionally causing miscarriages, stillbirth. That is a felony punishable by life or any term of years. In count number 6, it is alleged that you committed the offense of conspiracy to commit assault, pregnant individual, intentionally causing miscarriage or stillbirth. That is a felony punishable by life or any term of years and or $10,000. In count number 7, it is alleged that you committed the offense of unlawful imprisonment. That is a felony punishable by up to 15 years in prison and or a fine of $20,000. In count number 8, it is alleged that you committed the offense of dead bodies removing without medical examiner permission. That is a misdemeanor punishable by up to 1 year and or $500. Additionally, the prosecution has elected to charge you as a habitual fourth offender, which means that you have at least 3 prior either attempted or completed felonies in your past. That makes those felonies punishable by more than 5 years up to life offenses. Do you understand those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you cannot afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request an appointed attorney.
The court will make a referral to the public defender's office for the appointment of an attorney, will enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that these crimes had occurred, and 2, probable cause that you were the person who committed the offense. If the prosecution is not able to do that, the case will be dismissed. But if they are able to do that, you'll be ordered to stand trial in circuit court. Prior to the preliminary examination, there will be a probable cause conference, which is where your attorney and the prosecutor will get together to see if there's a way to resolve the case. Do you understand that?
Yes.
Mr. Bartholomew, you met with somebody from the Community Corrections Department and gave them a mailing address, an email, and a telephone number. Is that information all accurate?
Yes.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing in future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show in 01 there was a forgery, 02 in receiving and concealing, 200 to 1,000, 05 malicious destruction of property, 200 to 1,000, 06 driving the license suspended second, 06 driving the license suspended, 08 driving the license suspended, 10 driving the license suspended second, 10 driving the license suspended, and 11 an attempted CSC 3, 11 larceny 1,000 to 20,000. Also in 11 there was an attempted larceny in the building, and a joyride, driving the license suspended, and another driving the license suspended. In 14 there was a fail to comply with SOAR requirements. 17 failed to comply with SOAR requirements as a second. In 21 operating without a license. 24 failed to comply with SORA. In 97 there was is set aside for receiving and concealing $100 or less, not shown in the CCH without a local record. There is an NSF check over $100 from, I believe that's 2000. The driving license suspended from 2000. 05, there was a driving license suspended. 06, driving license suspended. 11, driving license suspended. And 21, failed display the license. I have reviewed the praxis. The praxis scores him at a risk level 4. Any comment regarding bond, Mr. Bartholomew?
Yes, Your Honor. We, of course, respect these are extremely serious allegations. Without disputing the fact that this defendant does have a prior criminal history, obviously, even though some of those prior criminal histories are also very serious, I would ask the court to note none of those were for these type of allegations. I have represented this defendant in the past, and what I would say is, to my recollection, he's always stayed in contact with the defender's office. He's always been to court when we asked him to be to court, if I recall correctly. I don't believe there ever been any flight risk concerns. He does have strong ties to the community. The address that I have, and I won't say it on the record, but it is the one that he's given us before, and I don't doubt he continues to have strong ties to the community. I know he's extremely low income, so I would ask the court to factor that in when setting a bond. I do realize there will almost certainly be a monetary bond, but I ask the court to factor that in. I also ask the court to consider non-monetary bond conditions for public safety when deciding if it can be on the lower end of that. I don't doubt he would comply, as he's always complied with all bond conditions. Perhaps no contact with alleged co-conspirators, GPS tether, house arrest, things of that nature. But again, I just ask the court to factor in everything that's been said so far today. Thank you.
Thank you, Ms. Carey.
Thank you. The people are going to ask the court to deny bond in this matter. Under MCR 6.106B1, the court may deny pretrial release to a defendant charged with murder. He is charged with first-degree premeditated murder and felony murder, along with several other heinous crimes. In this case, we have 2 individuals that created a plan. They conducted research. They brought Rebecca Park to their home. They forced her into a vehicle and took her into the woods, where they stabbed her, forced her to lie on the ground while they cut her baby out of her, ultimately causing her death and the death of the baby. This is as heinous and as awful a case as it could be. And I don't believe there are any circumstances in which Mr. Bartholomew should be granted any bond. Thank you.
The court does find, based on the probable cause affidavits that I have read, the search warrants that I have read, and what's been presented to the court today, that Mr. Bartholomew does present as both a threat and a flight risk to the community. As such, he will be held without bond. Thank you, Ms. Saki.
No problem.
There's a reserved seat over there. I'm sorry.
I just always got a few kind of things charged up. It's something.
portable electronic device to take photographs or audio or video.
Bartholomew.
This is the case of the people of the state of Michigan versus Bradley and Alan Bartholomew, this is the case of the people of the state of Michigan versus Cortney and Marie Bartholomew, case number 254994FY. We're here for an arraignment. Ms. Bartholomew, did you have the opportunity to meet with somebody from the defender's office either yesterday or today?
I did.
I have a complaint that alleges that on or about November 30, 2025, in Antioch Township and or Boone Township in Wexford County, it is alleged in count number 1 that you committed the offense of homicide, murder in the first degree, premeditated, upon Rebecca Park. That is a felony punishable by up to life without parole, and DNA to be taken upon arrest. In count number 2, it is alleged that you committed the offense of homicide and felony murder upon Rebecca Park. That is a felony punishable by up to life without parole, and DNA to be taken upon arrest. In count number 3, it is alleged that you committed the offense of torture. That is a felony punishable by up to life or any term of years, and consecutive sentencing may be imposed if it happened in place of confinement. In count number 4, it is alleged that you committed the offense of conspiracy to commit torture with Bradley Bartholomew. That is a felony punishable by up to life and or any term of years and or $10,000. And again, consecutive sentencing may be imposed if it happened in the place of confinement. In count number 5, it is alleged that you committed the offense of assault, pregnant individual, intentionally causing miscarriage or stillbirth. That is a felony punishable by life and or any term of years. In count number 6, it is alleged that you committed the offense of conspiracy to commit assault, pregnant individual, intentionally causing miscarriage, stillbirth. That is a felony punishable by life or any term of years. In count number 7, it is alleged that you committed the offense of unlawful imprisonment. That is a felony punishable by up to 15 years in prison and or a fine of $20,000. In count number 8, it is alleged that you committed the offense of dead bodies removing without medical examiner permission. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $500. Do you understand those charges and the potential penalties?
Yes, Your Honor.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to be represented by an attorney during any questioning that you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you could not afford one to be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes, Your Honor.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request.
The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that these crimes had occurred, and 2, probable cause that you were the person who committed the offenses. If the prosecution is not able to do that, the case will be dismissed. But if they are able to do that, you'll be ordered to stand trial in circuit court. Prior to the preliminary examination, there will be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there was a way to resolve the case short of going to trial. Do you understand that?
Yes, Your Honor.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing in future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, the praxis scores here at a risk level 2. The defendant's passed, I showed 15, the driving license suspended second, 18, driving license suspended, 19, allowing another person to operate in violation of the vehicle code, and 20, lying to a peace officer in a 1 to 4 year investigation, actually 2 convictions for that. In 05, a driving license suspended, that was set aside. In 05, a financial transaction device fraud withdrawal 200 to 1,000, that was set aside. In 14, there was a driving license suspended, set aside. In 18, false or forged ID, set aside. On a local record not showing the CCH, there was an 03 stray dog and a licensed dog, 04 unlawful plate, 05 attempt failed to report an accident, 15 driver license expired, 17 allowing unlicensed driver to operate, 19 allowing unlicensed driver to operate, and in 23 plead false report of a misdemeanor. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. We do realize these are very serious allegations. She does, as the court did note, have a prior criminal history, nothing anywhere relatable to this. I would ask the court to factor that in when setting bond. I have had contact with her in the past. I did represent family members of hers. I won't go into too much detail about that. What I will say is, without giving the address on record, I am familiar that she does have strong ties to that area. She does have friends and family and support structure in the area. She also has a variety of disabilities that I won't go into too much detail just for respect of her. But she does have upcoming medical appointments, MRIs, CAT scans, things of that nature, just so the court is aware. I don't believe she's a flight risk, not only due to the fact of her ties to the community, but also due to her need to do those medical appointments. I do believe that she would obey any non-monetary bond conditions the court placed on her if the court has concern for public safety, which we don't doubt would be appropriate in the scenario. No contact with alleged co-conspirators, house arrest, things of that nature. I do realize the court's not required to set a monetary bond, but I would ask the court to consider it, including factoring in her disability, her low income, and the fact that her prior criminal history doesn't have these type of allegations in it. Thank you.
Ms. Carey?
Thank you. Again, the people are going to request the court deny bond in this case pursuant to MCR 6.106B1, which allows the court to deny pretrial release to a defendant charged with murder. She is charged with murder. She's also charged with felony murder and 6 other counts, as the court read. I hate to repeat it, but to create a record in this case as well, I think no bond or being held without bond is appropriate. Again, this is a case of premeditated torture and murder. These two individuals created a plan, conducted research. Ms. Bartholomew brought Rebecca to their home. They forced her into another vehicle and took her into the woods, where they stabbed her, forced her to lie on the ground while they cut her baby out, and ultimately caused her death and the death of the baby. They then left Rebecca in the woods. This is, frankly, evil personified, and I would ask the court to hold her without bond.
The court does find, based on what's been presented to it today, the probable cause affidavit I've read and various search warrants I've read, the defendant is both a flight risk and a threat to the community, therefore she will be held without bond. I am going to order.
Your Honor, I have a
No. I'm also going to order that the defendant not have any contact with Bradley Bartholomew, and I'm going to sua sponte go back and add that requirement to his bond conditions as well. Counsel, anything for the record?
No, sir, thank you.
No, Your Honor.
All right, thank you, Wexford.
Everybody, thank you.
I will hold off on calling the next cases to allow